of two applications, fundamental applications. One is the adoption of our final analysis on trial with what others during the proceedings, in front of FIR against the branch in Mexico. So, and also application to set aside the order to vacate the other court made against my client, Nnamdi Kanu. So, for his revocation of bail. I've already filed an application to vacate that order, and they've not responded. The federal government has not responded to that application. So, ordinary, the two applications should be going on today. Adoption of a final analysis, trial with trial, and also moving an application to vacate that order. So, which the prosecution had indicated before now that he intends to reply on point of law because they didn't find any counter to that application. So, but unfortunately, his lordship is seriously indisposed on health ground. That was why he invited us to the chambers and explained to her that he's sick. So, and apparently looking at her, it's obvious that she's sick. She said it has to be in court today as a mark of respect for the lawyers, and also to compare her feelings to the lawyers, that she can be able to take any case today. It was an impromptu development, and from everything, all indication, also from her facial outlook and her countenances, it's obvious that she's seriously down. So, and advise us we should take it another date for taking for the two matters. So it's now adjourned to 31st of October for hearing of both applications. One to vacate 31st of October for hearing of both applications. One for an application to vacate, the other revoking the bail, and also revoking the bail, and also an application with final addresses on trial within trial. So the matter is now adjourned to October 31st, out of record, but to acknowledge to for hearing. So for hearing of these applications, of course, you know that as penultimate date, matter came up, the court revoked the bail of my client, and we found that the court has no jurisdiction to do that. So we have to file an application to get it vacated, and we shall be served on the federal government, and they not responded. So only that the prosecutor, Balabaran, should have indicated interest this morning. I want to respond on point of law, which if the matter has gone on, we will have a limited opportunity to talk, because if he has any facts to reply upon on grounds of facts, he will have also filed a counter affidavit to that effect, but didn't file. So I hope that on 31st of October 2019, we take the entire applications. Of course, you know the vacation starts in the next couple of weeks. So of course, at the view of our current health status, she may not be able to see before the vacation. So our vacation will end towards September, end of September. So obviously we're coming back in October. So that was what's informed the long adjournment. So thank you so much.
But there's one thing I want to understand, because given the fact that the case in question has an international awareness, so one may easily say that maybe they are running out of the case or something of that nature. Can you briefly kind of explain vividly whether the new adjourned dates, whether they will be available in the court or whether the court will proceed?
Well, as I had always been told, the federal government is not ready to prosecute this matter because they cannot prosecute the case on the back. One, there's nothing before the court for them to proceed. As you can see, today, the matter came up. Ordinarily, if my law is healthy, we have gone ahead with applications. So, as fundamental as application is, particularly the one urging the court to vacate the bench warrant issued against our client, then that if they had any matter before the court, they would have countered that application by verifiable evidence. But that wasn't the case. So that will show you that they're not serious. So, and as it stands, I don't think the court has taken further step in that order he made, because we filed that application promptly, and also punishing the courts with the facts, relying on documents that are very overwhelming. I'll convince the court to vacate that order, because we're talking about what led to our client's inability to present himself in court for trial. So the facts is in the public domain, and the world is also aware of the facts. We have supplied the court with the facts of what transpired in his house on September 14th, 2017, how his house was invaded by the military, and also what transpired he was able to get to where he is today. So these are facts that made it compelling for the court to hear this application. And also in the light of what the court law says under Section 3524 of the ACJL, that SCJA, that the court must satisfy himself, reason why the defendant is not in court to present himself for trial. Once it's founded on a reasonable ground, the court will not proceed. The court must investigate what led to his disappearance. And that's what we're asking the court. Let's look at the materials before the court and find whether the material is sufficient enough to ground to allow the court to proceed or not. But in the circumstance, we are firmly sure and certain that once that application is heard and the court will grant it, most likely.
Okay, which means we're expecting justice at the end, maybe by the next adjourned date, or
This adjourned date being 31st of October this year is principally for the hearing of two applications I already indicated. One is our final written addresses on trial within trial. You understand at the last adjourned date that the federal government witnesses came to the court and also to testify against Shidebe. And in course of the proceedings, I objected to the admissibility of the certain documents he wanted to rely upon. And that is the SI settlement he purportedly made to the SSS, which was made under duress. So, and in such circumstances, that document cannot be allowed to go in because it wasn't made freely, wasn't donated freely. So the court now puts to the test the voluntariness or otherwise of the admission of that document. That was what they called, what is called trial within trial. So the proceeding has been concluded and the court ordered for written address to be filed. We filed our own, they filed theirs, and we replied to that their own written addresses. So that will be first attend. Then before we move into an application, a competent application to vacate the order, invoking the bail of my client. So these two applications will go on that at 1st of October. So after that, we'll now take it off from there.
Okay.
Thank you.
And also remember also that we also have an application challenging the competence of the child before the court. That's an application. That application is pending the case between the fire against and the right Shimes there. So we are hopeful that once we are done with the adoption of our addresses on trial within trial, we invite the court to hear that application because it's a fundamental application that must be heard and disposed of. And in view of recent Court of Appeal decision in Nyama against fire against Nyama, that when the application is brought out on consideration of or otherwise is founded on consideration otherwise of the capability of the court to proceed, that the court must hear that application and determine upon it.
Okay, and finally, there is a case before the appellant court seeking the validity of the court tagging IPOB a terrorist organization. Up to today, we haven't seen anything.
Okay, the case came up that should be sometime last 2 months for hearing. The day before the date the matter was scheduled for hearing, the federal government filed a response to that appeal. So I will reply to their respondent brief. I filed a reply brief. So it's adjourned now for substantive hearing. So sometime September, October, according to the date, but I know it's going up under September. So after the hearing, then they will give us a date for judgment.
Okay, Barrister, what about the case about our brother Benjamin and his properties taken by DSS?
Yes, we have filed a separate case on that. We have filed an application for them to produce all his belongings in the custody of the SSS. So I also joined the AG Federation in that application on that suit. So it's coming up sometime next week for hearing because they file a period of objection. They're not saying that they're not contesting the fact that those properties are in their custody. No, they're saying that that it was brought under a wrong law. So I wonder what they mean by a wrong law. So we have replied to their objection, and it's coming up next week for hearing. So we had and delivered a ruling we delivered upon it.
Okay.
So
Barrister, please could you brief us on the sister case of this, following the cases of the shorties to show cause? You know, we understand on the last adjourned date there was a stay of proceedings. So via the appellate court or by virtue of the rulings of the appellate court. Please, could you brief us on the boundaries or the boundaries as regards to that? Any date so far?
No, I don't think the date has been given. But the fact that the judges has gone to appeal based on only the court delivered on 14th of November 2018. So when the court asked them to come and show cause why they will not fulfill the burden. So which the court delivered without hearing the applications before them. Because court ordinarily supposed to have listened to the application before them. No reason why they will not produce who they took on bail, the person they took on bail, before giving ruling. So the court gave that directive before hearing the application. So they've challenged it, and by the operation of the law and the standard rules of court of appeal, when the proceedings of this nation before the court of appeal, and as evidence to show that records have been transmitted before the court, the courts below will naturally stay proceedings, and that was what happened.
Yeah.
So, and the date, once the date is given, they will communicate us on the date of the hearing. So I'm hopeful. Let me hope they will hear the application, the appeal this year, probably this year. So that they extend their brief, they file their appellate brief before the court of appeal. I'm not sure that the federal government has responded to that appeal. So let me see how it goes. But you know, these are reasons why that application to vacate the bench warrant made by the court should have, because the application for the shorty to show cause and also reason why he's not in court, they are intertwined. They are the same thing. So you cannot differentiate them.
One begets the other.
Yeah, of course. So there's no reason that the court cannot proceed without that appeal being concluded. Yeah. And that's what I was saying before this court. Once that's part of ground why we are urging the court to vacate that bench warrant, because we have asked them to come to the court and show cause why they will not fulfill the bail bond. Reason being that the person they took on bail is not in court. You have to allow them to tell you why the person is not in court. So until when that is determined, that's the only way the court can make further order one way or the other. So, and once that is not done, the court cannot effectively and competently make an order for him to be arrested or for his bail to be revoked. So that's part of the reason why grounds upon which we have filed this application to vacate that order. You hear it all on October 31st. Oh, right. Thank you so much for.
But in addition, there is a tension about the arrest of one Mr. Justice today, and up to date, we haven't seen or heard any update about it.
Yes, we are on top of the case. We have already filed an application before the Federal High Court Umaya, where the arrest was action originated, and it came up a few days ago, yesterday, for hearing, and the court adjourned it to. Before then, the court made an order for them to either release him on bail or release him on bail, charge him to court before 13th of June 2019. But yesterday, the court further allowed them time within which to charge him to court or release him. And the court made a different order yesterday. In addition to order he made time before the court, that if he's not charged to court on or before 31st day of September 2019, that he will be entitled to unconditional release. But that notwithstanding, we have come to this court, to the Federal High Court Abuja, to challenge all the orders they obtain from this court, expert orders, because they obtain expert orders from this court, this Federal High Court Abuja here, to return justice to them, Emmanuel Emerike and Chibo. So we have filed a competent application before this court to vacate those orders, and those applications have been served on the DSS today. So we are waiting for them to give us a date to move the application to get all those onerous and the principal order to vacate it. Thank you very much.
Okay, sir. In the midst of all these abnormalities from incessant arrest, injustices upon IPOB members, so what do you have to tell the IPOB members at this point?
Well, I've consistently maintained the fact that this form of actions they are taking will not be alien. It will come on in the circumstances they found themselves, because they must be doing something to provoke the IPOB peaceful agitation group into going into violence. So I will still continue to urge them to maintain calm. Whatever they are doing today, we are going to challenge it in court, and in court we get justice. Our holy hope lies on the court. So because if they now went out of their way, on account of the actions that are taken against them now, incessant arrests and the illegal detention in various police custody and SSN centers, and going to violence, then they will now be justified in the allegation that they are a dangerous group. So they are now taking these actions to provoke them into going into violence. So I'll continue to urge them to maintain peace and go about the agitation peacefully. The agitation is also protected under respect laws and all international conventions, the United Nations articles on human rights. So I urge them to operate at all times within the ambit of laws. So their right is take stance, and even under our law, they sorry rights. So you should not, against all odds, go into violence. That has been my advice, and I still maintain that position. Thank you so much.
Thank you very much. You all of you here knows that we are not allowed to speak to the press according to our bail condition. But I want to use this opportunity to say that I urge Biafrans and the people of good conscience around the world to pray for quick recovery of our mommy at law, Justice Binta Nyako. We wish her quick recovery. Thank you.